House Energy Policy Committee will come to order. Clerk, please call the roll.
Chair Glenn.
Here.
Representatives Hawk.
Here.
Barrett.
Here.
Cole.
Here.
Tedder.
Here.
Bolino.
Here.
Farrington.
Here.
Griffith.
Here.
Johnson.
Here.
LaFave. Glower.
Here.
Riley.
Here.
Lisinski.
Here.
Deonda. Garrett.
Sure you
And
know.
Larry. Elder.
Sure you know it's better for next week.
Green.
Very lower. Here.
Sneller. Mr. Chair, quorum of the committee is present.
Thank you, Mr. Clerk. And we have with us today, what's the clerk's name today?
Carnegie.
Carnegie is a temporary replacement until we have this position filled. And that's Representative Lauer and Hauk, in case you come and do the roll call again. Lauer and Hauk, because Representative Lauer or Lower has just been subjected to significant ridicule.
By who?
And that's right. Now, apparently, the Elections Committee is having some significant hearing this morning, which has some of our members, plus Representative LaFave has had car trouble and expects to be here in about 30 minutes. First witness we're going to have up today is, I need a motion to approve the minutes of last week's meeting. Representative Lauer so moves, without objection so ordered. First witness we're going to have today is Sally Talberg, Chairman of the Michigan Public Service Commission, and Ms. Talberg needs to leave at 9:45. Vice Chair Lisinski also has to leave for a funeral at 9:45, so I'm going to give her discretion if she has questions of Ms. Talberg. Make sure we get her questions in. And without further ado, Ms. Talberg, if you'd like to come forward, you know the drill. I assume you've got a statement, and then we'll open the floor for questions from members.
Good morning, Chairman Glenn, Vice Chairs Hauk and Lisinski, and members of the committee. My name is Sally Talberg. I'm the chairman of the Michigan Public Service Commission. I was appointed by Governor Snyder in 2013, so just passed 4 years on the commission and became chair in January of 2016. The purpose of my testimony today is to provide an overview of the commission's decision to establish capacity demonstration requirements for electric providers pursuant to Section 6W of Public Act 341. This pertains to a case before the Commission, docket 18197. I'm available to take questions, but I do want to provide an overview of kind of where we came out on this. Section 6W of this act was passed by the legislature and signed by the governor to enhance the reliability of Michigan's electric grid, and specifically requires all electric providers to secure sufficient supplies of electric capacity to serve their anticipated needs 4 years into the future. I've worked in utility regulation and energy policy for nearly 20 years, including serving on the staff at 2 public service commissions, and this is one of the most controversial and complex topics during my tenure. Some of you talked about having fun last week in engaging in this discussion, and I would say, you know, when I think about fun, it's certainly the December 21st when this bill was signed and the celebration that ensued. There was a lot of anticipation. I would say it's fair to characterize the current situation that the honeymoon is over, and a lot of issues given the framework of the legislation to be worked out by the Commission with through our processes and stakeholder engagement. On September 15th, just this past Friday, the Commission issued an order in this matter, and it was a final order. We clarified the requirements and process for each electric provider to make these so-called capacity demonstrations to the Commission. And the Commission is providing tremendous flexibility for electric providers to use a broad range of options to meet the new requirements, such as new or existing generation, purchase power contracts, new or existing energy waste reduction or energy efficiency programs, and demand response, which is shifting customer demand off of peak times. Capacity supplies can be sourced from out of state, but the electric provider must own or have contractual rights to the supply as mandated by the law. This will improve reliability because capacity at the state and regional level will actually be secured in advance, whether by taking advantage of excess supply or investing in new resources. This approach is also cost effective because the electric provider is in the best position to figure out what the lowest cost options are to serve their customers' needs and to manage the risk of importing capacity from out of state. Unlike approaches in some states that provide incentives or subsidies to specific types of generation, such as Illinois or New York, in an attempt to protect reliability or meet other policy objectives, Michigan's approach is also fuel neutral. That is, electric providers know what the requirements are 4 years into the future with certainty, and the provider, not the state, determines what fuel or combination of fuels makes sense. So they can take into account environmental performance, plant performance, fuel diversity, reliability, risk, and other factors, cost, of course. Due to fluctuations in customer demand and the availability of resources that occur over the 4-year period, the Commission is also allowing electric providers to plan on up to 5% of their capacity portfolio to be acquired through the annual auction. So when they come in and show the first 4 years that they have supplies locked up, 5% can be set aside to acquire through that auction. This auction serves as a clearinghouse to buy and sell capacity for the upcoming summer. It's administered by the grid operator, regional grid operator, that's under regulation by the Federal Energy Regulatory Commission, and it's the Mid-Continent Independent System Operator, MISO, not miso like the Japanese soup. So based on MISO's data, this 5% is consistent with the historical use of the auction at the aggregate level in Michigan. And in the first year, due to the overlap of the timing of the new Section 6W requirements and the Commission's review of the filings that will come in through that, and the auction timing, which kind of goes at the end of March, the Commission's allowing providers to purchase 100% of their capacity through the auction because they will be able to have contractual rights to such capacity. And this also helps us achieve consistency with the federal requirements. There's a lot of state, federal jurisdictional considerations to keep in mind when setting this up. The Commission affirmed its legal authority under Section 6W to apply a local clearing requirement, or LCR. This has been a topic of considerable interest. And we determined that that can be applied to individual providers, but we're not imposing the requirement for the first 4 years. So for planning years 2018 through 2021, that will not apply to an individual entity, that they have to meet, so of their overall supplies, that they have to meet some portion of that from resources within the local zone. The issue has generated a lot of attention, but I can just sit here today and say that the Commission carefully considered the law in its entirety and the diverse viewpoints and legal arguments. The LCR was not removed from the law. You should have copies of a Q&A about the Commission's decision as well as a copy of Section 6W, and we've gone to highlight in yellow the key provisions that talk about the local clearing requirement. What was removed from the Senate version was a specific methodology on how to determine what the LCR was and how to allocate it to individual providers. You've got the copy for your reference, but I just want to walk through and kind of explain how the Commission looked at all these different provisions to develop a cohesive framework. The law explicitly defines local clearing requirement and the Commission's role in setting it. You can see subsection D, 12D on page 4. Subsections 8, 8B, and 8C discuss the Commission's role in determining the LCR as part of the capacity obligations for electric providers and obtaining related technical assistance from the grid operator, MISO. The appropriate independent system operator is defined in the statute as MISO. That's on pages 2 and 3. Stakeholders have talked about specific sections of the law to support their arguments. The Commission sought to give meaning to each and every provision. For example, in order to agree with the statement that the LCR was removed from the law, you have to assume that the legislature and the governor intended the LCR only to apply to nonprofit utilities, specifically small, municipally owned and electric cooperatives. A more reasonable interpretation of Section 6W8B is that the law was providing additional flexibility for these nonprofit utilities to aggregate their supplies to meet the individual local clearing requirement. They do that today for energy waste reduction. They do that today for power supply. So it's very much akin to the business model where cooperatives and municipals often work together to meet their collective needs given their size. And notwithstanding this legal authority, and let me just reiterate that the Commission's well aware that we're a creature of statute and the only powers we have are granted by the legislature. But we feel like we're squarely within the bounds of this law in interpreting these provisions. And notwithstanding this legal authority, the collaborative process over the last few months just has not produced the kind of information necessary for the Commission to reasonably determine how to design and allocate the locational requirement and ensure consistency with federal requirements. Allocating the local requirement based on each provider's proportional share of their customers' demand is easy to do, but that was what was taken out of the Senate version. And the Commission was very clear that such approach would not be equitable, would not be reasonable, could lead to over-procurement of power supplies, thereby increasing costs, and would give incumbent utilities like DTE Energy and Consumers Energy a distinct advantage. I refer to page 38 on the Commission's September 15th order, and we also talked about this in the June order. The Commission remains interested in an incremental approach in which you forecast incremental supplies that's needed to meet MISO's local clearing requirement over time, and then assigning that. It would be a fraction of what a proportional share would be. But what's really important for the Commission in our decision making is to allow all parties to have due process, have experts that can actually put forward information, it gets tested, and then the Commission can make an informed decision. But I can assure you that we'll be considering issues such as cost, equity, reliability, and the law when proceeding forward. So what we're going to be doing is initiating, likely sometime in October through an order of the Commission, a formal process with a hearing to determine the proper methodology and allocation for the locational requirement. This would go into effect in 2022. And during this transition, the Commission finds that Michigan homes and businesses should have adequate supplies under the law's proactive approach to reliability and what we've set forth in the September 15th order. We recognize that resource adequacy, having enough resources over the long term to meet electricity at peak demands, even when you've got generators going offline or transmission lines tripping off and hot summer days. This involves both state and federal regulators, and we're implementing the provisions of Section 6W with a commitment to maintaining consistency with those requirements. In setting these obligations as mandated by the law, the Commission does not seek to supplant or replace the well-established MISO auction process, but instead complement that approach by ensuring all electric providers, whether they're municipal utilities, electric cooperatives, alternative energy suppliers, or incumbent investor-owned utilities, to contribute to reliability. And the Commission's, I truly believe, I've worked in Texas setting up their electric choice market. I've been in Michigan for a number of years working in this area of utility regulation, and I think the framework that's put forward in Section 6W as implemented by the Commission will allow choice to be viable going forward, but also ensure that all providers are contributing to reliability. And we're going to continue to work on this and implement these provisions in a consistent and cost-effective manner. When you have an open and transparent process that allows all voices to be heard and considered, and we follow the letter of the law, I'm confident that the Commission is dutifully serving the residents of this state, all 10 million Michiganders. And the Commission greatly appreciates the technical assistance from MISO. The legislature was wise to expressly require such coordination, but I can say we've worked closely with MISO, both the staff and the Commission, for years to find a reasonable solution to resource adequacy challenges presented by Michigan's unique hybrid electric market structure. And I also want to acknowledge our dedicated staff who've remained focused, amidst the political storm. They've worked with diverse stakeholders to find common ground and present options for the Commission on this complex topic. So with that, in my prepared remarks, I'm available for comments.
I will start, Madam Chair. The folks making up the broad coalition who are involved and supportive of electricity choice, without whose support this bill could never have become law in the middle of the evening, middle of the night last December, strongly disagree with your characterization. The words that I've seen them use in the media is betrayed. And I think there is a resort here to semantics, maybe word games, when you say that the LCR was not taken out of the law, because anybody who was actually involved, and everybody else seems to know what the deal was. Now, the PSC has demonstrated that you have the authority, unless some court or the legislature by subsequent action stops you, from reaching a different interpretation after the fact. I'm hopeful that Representative Verheulen's going to be able to make it in this morning. He had a conflict, but if he can, he will be here, I think, after you're no longer here, to give us firsthand report as one of the two legislators who was in the room as to what the deal was. But all of those excuse me, who relented in their opposition because of the perceived threat to electricity choice last December did so on the understanding from Representative Verheulen and Afandoulas as firsthand reporters on what happened in the room with the governor's office and all the interested parties in their negotiations. The deal was we have removed the local clearing requirement as applied to AESs. So yes, you may be correct that it would be assuming it only applies to nonprofit utilities, but that's what everybody understood the deal to be. I've talked to members of the media who said everybody knew what the deal was. You know, we can come up with all kinds of interpretations after the fact, but in the middle of the night on December 16th at 4 o'clock in the morning, everybody understood what the deal was, and it was on the basis of that understanding that the votes were accumulated to be able to make this become law. I have some questions as well. I don't see much distinction between 2018 and 2022 because even though the new rule, which those of us who were involved in the deal last December don't think you have the authority to do under the statute, expressly because it was taken out of the section regarding alternative energy suppliers. And the State Court of Appeals has ruled that if the legislature expressly takes something out of a section, you cannot then interpret it to require the very thing the legislature purposely, knowingly took out, the change they intended to make. So the imposition of such a rule in 2022, as I understand it from the companies who actually are involved in providing electricity choice customers their power, is that since they have to show proof of access to capacity 4 years in advance, that when they do so in February of 2018, as I understand it, it'll be under the rules as they are now, but that as of February 2019, so a year and a half from now, at that point they will be facing the possibility of having to meet a local clearing requirement 4 years in advance, and it will be at that point, only 18 months from now, so I'm told by the companies who are actually doing this, at which they will have to decide whether they can continue to do business in Michigan if they're forced to buy electricity from the very people that they're competing against, DTE and consumers. So whereas it sounds like you're putting it off for 4 years, I'm told in practical terms that it's only 18 months, not much of a transition. And I don't, you know, the staff in their recommendations talked about all the various harms, and they said don't do it in 2018. But if it's going to cause these harms, which they said it will do nothing to improve reliability, it'll damage reliability for some customers, according to your own staff. It'll be inconsistent with MISO rules, which as I understand them, and you can correct me if I'm wrong, is that currently alternative energy suppliers can get their power from any source, according to MISO, and that this is a restriction not consistent as on page 3, subsection C of what you handed out, says that it has to be consistent with federal reliability requirements. And since they're allowed to get their electricity from any source, it would seem that if you discriminate against the MISO market, that that's not consistent with current federal requirements. We also had a federal judge Posner, who recently said that any such requirement is a discrimination against out-of-state power, which violates the U.S. Commerce Clause. I guess that may have to be tested in a formal case as well. But I don't understand the distinction, and please explain it to me. All these various things that your own staff warned you against and said you shouldn't do this in 2018, explain to me how the challenges and threats to the electricity program that your staff warned you about, how does that change, regardless of which year you implement them?
So let me just start by first indicating that the Commission interprets the law based on the letter of the law. I think there's different opinions about what was negotiated in the middle of the night. Other sides think something far different was negotiated. And the Commission, none of the commissioners were there. We look at the law and we interpret the law. And if it's unambiguous, the issue of legislative intent doesn't even come into play. And again, I would just stress that what was removed was a specific methodology that the commission has blatantly and clearly rejected. And that was the underlying concern that the staff had with respect to potential cost implications. So, so that's number one. Number two, the law does not distinguish between alternative electric suppliers and other utilities in terms of the substantive obligations. I would give two exceptions where there is some uniqueness. First of all, the aggregation option is clearly provided for the nonprofit utilities, municipals, and co-ops. And second, alternative electric suppliers actually have to show each of the 4 years that they have the capacity lined up, whereas the incumbent utilities only have to show in the 4th year. Now, the commission has asked, based on how we've done this in the past in terms of looking at supplies over time, that we've asked them to continue to provide each of the 4 years, but they're not required under the statute to do so. You are correct, Chairman Glenn, that the local clearing requirement that would be handled through a contested case at the commission and determined in 2018, we're expecting the summer timeframe, would apply. It would apply to the 2022 planning year, but the filings that would come in December of 2018 and for alternative suppliers in February of 2019 would have to show for 2022, 4 years out, that they can meet that requirement. We haven't determined what that is, though. So I think, the notion that this is going to impact reliability, this is going to increase costs, it really is not only premature, but the instances where those concerns have been raised have been outright rejected by the commission. And then lastly, on the point about inconsistent with the federal requirements, there are no forward federal requirements, years 2, 3, and 4. We've synced it up for year 1, and we've worked with MISO, who's been very clear in their comments to the commission that states setting their own requirements, going forward requirements, does not violate their tariff. And so what we're putting in place is what we think is the purpose of this legislation, is to establish those forward requirements and ensure that we can, over the long term, meet those requirements at the federal level. And the purpose for those is reliability.
Under MISO regulations currently, where can the alternative energy suppliers get their energy now?
It depends. Some have their own generation, others do not. I don't want to divulge confidential information that's been revealed to the commission, but there are some that rely on the annual auction. So each year there's an auction where you can buy excess supplies if they're available. If they're not available, you get charged, certain amounts. And all entities have to participate in that or show that they have their own resources for that upcoming year to MISO.
Can they get it from any source?
It depends on what you're talking about. There's really two separate requirements. There's a planning reserve margin requirement, and there's a locational clearing requirement. For the planning reserve margin requirement, for just kind of purposes of keeping it simple, yes, you can get the resources from out of state. There are qualifications in terms of how things get counted, but yes, you can get them from out of state. And the commission has allowed that for these first 4 years. The locational requirement, it depends on whether you're in the auction or you're submitting kind of your own resource plan to MISO. If you submit your own resource plan to MISO, you get allocated a proportional share of that local requirement. In Michigan, it's pretty unique. And those, to meet that local clearing requirement, the resources have to be from the local zone. So for Michigan, we're talking about Zone 7, which is through here, except for the southwest corner of the state. And 95% of the resources have to be from within that zone. Now, MISO does have some exceptions where if an entity, let's say a generator in Indiana or Illinois, has generation and they go through a process to get certain transmission service, they can actually count it towards that local requirement, even though it's not physically located there. And I think that's an important issue and was, discussed a lot during this legislative debate about any resource, because I think there were attempts to restrict such generation from being able to count towards that local requirement. And that would have been significant, particularly for certain providers.
So MISO has said they don't have any problem if the commission decides to impose a local clearing requirement, but currently, does MISO require one?
They do.
And are you adding anything to that?
We are not.
Okay, so
We are
nothing
looking
will,
at
nothing will
setting-
change?
We are looking at, so for the first 4 years, nothing changes.
Well,
From the standpoint on the locational requirement.
Right.
The MISO zonal requirement will apply, and we will set up for 2022 and beyond what share each provider should contribute towards a local requirement.
so the the requirement you're going to set up in 2022 becomes effective in December of 2018, and that is or is not the same as MISO's policy now?
It is consistent with what MISO is doing. It would be looking out. MISO only has requirements for the current year. So they look at the upcoming summer, whether there's enough capacity. And that model was by design because the majority of the 15 states in MISO are fully regulated. They have long-term resource planning. And the 2 states with electric choice, Michigan and Illinois, have been the subject of considerable discussion, major filings at FERC to address the fact that MISO's market does not provide adequate incentives to ensure long-term resource adequacy in the choice markets.
Madam Chairman, the purpose of testimony before the committee is hopefully to enlighten the committee, and if nothing changes, you wouldn't have people talking about being betrayed. You wouldn't have people claiming that the deal was broken. So obviously there are going to be major changes made, and when you say no, nothing will change, that doesn't serve to enlighten committee members as to understanding, at least in my opinion. It sounds to me like word games when something's drastically going to change, and I ask you if it's consistent with current requirements, and you say yes. I mean, something is going to change significantly. And that'll be my last comment. If you want to respond to it, then I'll allow questions from other members, starting with Vice Chair Lisinski.
Thank you, Mr. Chair. So I just want to clarify a couple of things. So when I read the legislation, I'm going to paraphrase, but it says that whatever we do in our energy markets here in the state of Michigan has to be consistent with federal regulation, and MISO is the entity that regulates our capacity and reliability stability. Is that correct? Whatever we do in Michigan has to be consistent with MISO and with FERC.
Correct.
Okay. MISO has determined that we need to generate 95% of our power within the state of Michigan, or within that Zone 7, which is essentially the mitten. And my understanding is that's because of our geography. We have limited transmission lines coming in from other directions. We're transmission limited. And because of the amount of energy that can flow into our state, essentially from the bottom of the mitten, we have to generate most of our power, 95% inside our state. So if 95% is to come in from inside our state, but choice is already at 10%, and if we have no requirement on any of our choice providers to generate any of their capacity from inside our state, how do we ever reach 95%?
We would depend on all of the local utilities to buy all of their, or have all of their local generation within the state. Let me just give you a little perspective on this local requirement. So MISO looks at Michigan as if it's an island. And then, as you indicated, we don't really, and they figure out, okay, how do you maintain, like think of being Hawaii, how do you maintain this reliability standard if we were an island? But in reality, we don't operate as an island. We're interconnected with a interstate grid. And so it's like we have this bridge to bring in capacity from elsewhere. So they subtract off the amount that we can import in. And the amount ends up being that 95% has to be located locally. And utility, I mean, just for reference, incumbent utilities have like 20,435 megawatts here locally in Michigan, and the local clearing requirement is 21,109. So the numbers just don't, like, everyone needs to contribute in some way to this local clearing requirement, or over the long term, we may not meet it. And we're kind of right, we just hover around it. And it depends on, you know, it can change from year to year as well. So as transmission changes and other factors. And that's why the commission wants to be really mindful in how this is set up, because of how it can fluctuate over time.
When I look at some of the notices we've received about a nuclear plant going offline or about coal plants going offline, are we saying that, or is what my colleagues may be saying is the perception that if there, so if a nuclear plant goes offline, if a coal plant goes offline, that's less local generation that's being created. And if the interpretation that the chair, I think I understand, is saying that then that burden of creating more local supply, that none of that burden should fall on alternative energy suppliers, would we be creating a different playing field then for folks, our energy suppliers who serve into our state, if our choice providers don't have to provide any locally generated resources, but our incumbent utilities, our nonprofits, and our municipalities have to provide then 100% of the local clearing requirement? Would that be the impact if there was zero?
I think so, but I also would note that the arguments that everyone, you should take the, 21,000 and just divvy it up based on everyone's share is also not equitable and creates an uneven playing field. So a lot of this generation that exists in Michigan was built under, it was built in the 20s, 30s, 40s, 50s, 60s, 70s, 80s, and far, before any discussion of a choice market or anything of that nature. And so I think because so much of that was built locally for that reason, it doesn't necessarily, and it's going to be there regardless, and the utilities kind of have service areas, so it's a natural place for them to place generation. So what the commission's trying to figure out is what portion, we know we don't want to go below this requirement over the long term, because what it means when you don't meet the local clearing requirement is that you're not meeting the reliability standards. Mm-hmm. There's a greater probability of having an outage due to lack of supply. And so in order to try and meet that, we're trying to figure out how do you make sure everyone contributes so there is a level playing field, but recognize everyone's kind of coming to this in different positions.
So my last question then is, so then, like most things in life, the answer of 0 is not correct and the answer of 100 is not correct. So 100% proportional allocation or a 0 requirement is not correct. So as we look for that proportion in the middle, my understanding is there was a proposal by the Michigan Public Service Commission this spring to set up an auction device that would allow alternative energy suppliers to participate in an auction to get these local clearinghouse requirements. And could you explain why that wasn't allowed? Because my understanding is it would create a bifurcated or two separate markets, one for incumbent utilities and one for alternative energy suppliers, and FERC deemed that as not viable or not something they would be willing to accept.
So Section 6W had 3 options. The first 2 were embodied in a proposal that MISO had put forward to FERC, and those 2 include a forward capacity auction. This is done in the Northeast, where rather than MISO's current, just for the upcoming summer, they look out over 3 years and have people line up supplies through an auction mechanism. The other option was a prevailing state compensation mechanism, and that would be an option that if a state elected to go down that route could set up basically sort of the framework that we have with the state reliability mechanism that we're implementing now, but MISO would have more involvement in doing the verification of the capacity resources and just a greater level of interaction. Those 2 options, the commission under the law was supposed to evaluate which would be more cost effective to implement. So we thought that was going to be the proceeding that we would be having. now to determine. But in February, in a rather abrupt order, the federal, the Federal Energy Regulatory Commission rejected this proposal. The statute in 6W, though, had a backstop, and that's what we're implementing today.
Okay, thank you very much.
But each of those other alternatives, the prevailing state compensation mechanism and the forward auction, would have had a forward local requirement.
And that was deemed as not viable by FERC.
Not because of it was because the FERC was concerned having kind of two different, a forward auction and then the rest of the states having just the current annual, and how those two would interplay, and given the small size of this forward auction, that it may not even be viable.
Okay.
So that was sort of the basis on which they rejected the application.
Thank you.
I mean, I think it's, hybrid markets are complex.
Thank you.
Members of the committee, Chairman Talberg changed her schedule to be here, and we're going to respect her availability for another 7 minutes is what it looks like, and we've got Representative LaFave and Representative Barrett. So let's give both of them a chance to ask whatever question they have, and then we can continue our discussion thereafter. Representative LaFave.
Thank you, Mr. Chairman, and thank you very much for testifying today. The representative from Calumet and I have been speaking a lot about Zone 2 of MISO region, the other peninsula, and I'm just wondering, because I've had conversations with some that tell me that the choice market in the Upper Peninsula is below the 10% mark, and just so you understand where I'm coming from, I pay double the electricity in parts of my district and 3 times in others. So if you could answer, are there portions of Zone 2 or the Upper Peninsula that are below the 10% cap, where those are, and frankly, if we have the ability to produce 95% of the electricity in the Upper Peninsula. My understanding is we really don't right now, and I don't know, barring building another generator, which would make energy prices go up even higher, what are we going to do to drive down rates, because we just cannot be competitive for manufacturing up north.
So the Upper Peninsula is certainly unique. I'm trying to find the reference for Zone 2, which covers the Upper Peninsula and the eastern portion of Wisconsin. The local clearing requirement set by the Mid-Continent Independent System Operator is not 95%. It's a lower amount, and I was trying to grab that number for reference. That zone actually has a surplus of capacity. A lot of generation was built in including relatively new coal plants in Wisconsin, and so it does not it's not constrained from the standpoint of resource adequacy. But I can think of no better example than the Upper Peninsula when you think about why this local clearing requirement exists at all. You can't put all the generation in one portion of a big region, because you'll have local reliability problems. And those are the challenges that the Upper Peninsula faces. With the Presque Isle plant, if you take that out of service, you literally have issues where you can't keep the lights on throughout the UP. And so you need to have generation dispersed throughout the region so that in real-time operations you can actually have reliable power. So the commission in the Upper Peninsula, again, the local clearing requirement is not as significant of an issue. In terms of the, and I'll try and find that number for you. In terms of the,
It's page 34.
oh, okay. Yeah, so in Zone 2, the Upper Peninsula and Eastern Wisconsin, it's about 89%. But again, that's from within that whole zone, and there is a surplus, so it doesn't have to be within the Upper Peninsula. The choice participation in the Upper Peninsula, there are some industrial customers that have, and large customers that have taken advantage. So currently, there is choice load in Cloverland Electric Cooperative Service Area, the Upper Peninsula Power Company, and UMERC, the Upper Michigan Energy Resources, which used to be WEPCO and Wisconsin Public Service, kind of now combined. So those three have, and I think it's fairly close to 10%, like the full amount up to the cap under the statute. The other service areas in the Upper Peninsula have not, nor do I think they've ever had any choice participation. So that includes entities like Alger Delta and others.
My understanding is that, thank you very much for your answer, and I really appreciate that. My understanding is that mining has a carve-out of the energy. Mining is statutorily written in so that they are perpetually allowed choice in the Upper Peninsula. So if you exclude the mines, that the mines being excluded expressly from the legislation, the other power consumers, they would comprise up to 10%?
Mm-hmm. That's correct. So if you add the mines in, and they were on choice for some period of time, it's about 85% of that particular utility's overall customer base. So very significant.
Of the overall electricity usage itself?
Of annual sales of that utility, correct. They're a very, very large customer amidst a very small population base.
Representative Barrett.
Thank you, Mr. Chair, and thank you, Chairman Talberg, for your testimony. Would you agree that the Public Service Commission is an apolitical body in state government?
I would agree with that characterization.
Okay. I'm curious if there were any influence of politics. You know, certainly this committee was very public with the efforts that our chairman was contemplating undertaking and whatnot, and I'm curious if there were any discussions amongst commissioners regarding that, and if that influenced the decision of the commission at all.
I guess I don't understand your question. So the commission by statute can have no more than 2 members from any particular political party.
Right.
And you can't be an officer.
Right. I just mean that the very public discourse that was taking place on this committee and potentially taken by the legislature, if that had any impact on the decision that was made, particularly in regards to the date change for when the decision was announced and everything else, if that was influenced at all by this committee or the legislature and the public statements made by members of the legislature regarding the Public Service Commission.
The commission did not change its date. We set a target initially for the end of September, and we're committed to getting this decision out in as timely as a manner as we possibly could, because we know entities have to make plans and arrangements to be able to comply with the requirements. Had I had a chance to testify previously or had some greater engagement, I think it would have been, more clear in terms of what the timing was going to be. But we needed to make sure, even going into that week, that we had every piece of that order lined up. We wanted to make sure that we were proactive in getting communications out to interested parties, so we produced the Q&A document, and it takes a lot to line those things up. I've been committed at the commission to timely decisions across the board, reducing any backlogs, and getting our decisions out as quickly as we possibly can, because we understand the implications for them. No, there's no, I can say unequivocally, there's no politics being played by the commission. We've been focused on trying to sort through these complex issues, understand the law, and put forward, a coherent order that provides needed direction.
And I appreciate that. Would you say then, if that were the case, why postpone this impact of this decision by 4 years or even a year and a half from now, at which time this legislature will be dissolved and a new legislature will be here and potentially different members and whatnot? Was that, again, I question whether or not that had anything to do with the political posturing of what's taken place or the political discussion of today.
Madam Chair, before you respond, I just want to let you know you're on your time at this point. So.
Okay. I can understand how things could be characterized or perceived that way as sort of punting the decision. Right. But what was really clear to us at the commission is that we did not have the information on which to to base a decision, and we can't make arbitrary and capricious decisions. Could I try and figure something out on my own or have our staff do that? Certainly, but we can't do it in a vacuum, and we need a record that can form the basis for the commission's decision so it can be upheld and has integrity over the long term. So it was one of necessity, quite frankly, where we just did not feel like there was adequate information on which to base a decision. And then second, why I would typically be concerned that we had to wait 4 years to be able to implement this, or actually like in the 5th year. The most recent outlook from a capacity standpoint, combined with the other requirements in this order, give us assurance that we'll be able to make sure that supplies are arranged in the near term. So from a reliability standpoint, we think given the current outlook, and again, that can change. It changes drastically from year to year in significant ways, both up and down in terms of how the outlook looks at the regional level. And we don't have control over that generation outside of the borders of the state. And so but the new requirements do require everybody to line that up now. So it's not just like sitting there as a hypothetical that in year 3 or in year 4 they may be able to access. They're going to have to go and make those arrangements. So with that requirement and the overall supplies that appear to be available, the commission thinks it was okay from a reliability standpoint to do this as kind of a transition process while we can focus on making an informed decision that's equitable and reasonable.
Thank you. I apologize for holding you over. Thank you.
Anything else?
Madam Chairman, I'm going to say this while you're here, not after you leave, to illustrate the chairman's point about the projections changing dramatically. All of last session, we were told that, in the chairman's words before the Senate Energy Committee, that Michigan might go dark, consistent with the scare tactics of the television ads of the utilities, that we're going to have a shortfall, which the average citizen thought meant a shortage, encapsulated by the summary that Michigan could go dark. And then as soon as the energy legislation passed, now we find suddenly that we have enough electricity to last us for years in the future, even enough that we can shut down a nuclear plant. So yeah, they do change based on which piece of legislation is before us. Didn't want to say that after you left, so in case you wanted an opportunity to respond.
One quick note, the big swing this past year was that there was significant amounts of nuclear generation and coal generation in Illinois, another choice state, that was announced for retirement. And when you take that out of the market, we would have a shortfall. So Michigan's short position combined with Illinois would have made the entire 15-state region of MISO short of capacity, not meeting their planning reserve requirements for the entire region. That changed. Illinois, just like Michigan, in December of last year passed legislation. They're providing subsidies to keep the nuclear generation online. And when you fold that in, the outlook looks very different. There is still uncertainty. Those issues are, being challenged at FERC and with the courts, so it could swing another way if that gets determined to not be lawful. So I think it's important that, the proactive approach in Section 6W with respect to reliability, is making sure that we're taking appropriate steps in the state to protect reliability.
Thank you, Madam Chairman, and we appreciate your changing your schedule to be here for testimony today. Members, I want to read to you just to summarize the position that's argued by those of us who were involved in the issue last term. This is a letter signed by Chris Affendoulis and Majority Whip Rob Verheulen, who, to my understanding, were the only two legislators in the room. My understanding is in the governor's office, at least in our caucus, the Republican caucus, among members of the media, nobody was in doubt about what the deal was. You can say all day long what you think it was after the fact, but those who were involved, as reported by the only two legislators in the room, the language related to the imposition of a supplier-specific local clearing requirement obligation on capacity demonstrations on alternative energy suppliers, in particular, was a significant obstacle that was removed from the Senate-passed version of SB 437. The substitutes deliberately removed this contentious language, and in doing so, a compromise was reached. The final language clearly allows AESs to use any resource allowed by MISO to meet capacity obligations without reference to local resources. We have strong concerns that the imposition by the Commission of any requirements on AESs in excess of those MISO requires of load-serving entities violates the legislative intent of PA 341 and will place a significant additional burden on schools and businesses in our districts and all across Michigan. And the Michigan Energy Cooperative, Schools Energy Cooperative, estimates that's a price tag of $17 million a year for our public schools alone that will have to come out of the classroom. Affendulis and Verheulen continue, it will also threaten the sustainability of the retail open access program, that's the electricity choice program, the viability and continuation of which was a primary goal of the legislation and the intent of our substitute. We urge you to refrain from levying such requirements in your implementation of PA 341, as we believe they are contrary to the legislative intent and final compromise, according to the two legislators who were in fact representatives of the House of Representatives in those negotiations. So I don't think anybody except the Public Service Commission is in doubt, unless they are reinterpreting, casting a new interpretation after the fact because it's to their benefit, i.e. the interpretation apparently claimed by the utilities that obviously serves their financial interests, and that's their job. But at the point at which this legislation was passed and became law, there was no question on what basis that agreement was reached, and that was that no such local clearing requirement be imposed on alternative energy suppliers in particular. And we've got at least one federal judge saying it violates the Commerce Clause of the U.S. Constitution. That only FERC, only the federal government can regulate electricity sales between states, and that if you have a rule imposed by one state that discriminates against a particular source just because of where it's located, that violates the Commerce Clause. Well, that's the judiciary branch. They'll get to sort all of that out. All we can do is set policy based on trust in each other. This is not even a question anymore, at least it wasn't in the middle of December last year, of whether you agree with a local clearing requirement or not. It's whether or not we trust each other when we're told this is the agreement. And on that basis, you cast your vote. The Senate wanted a local clearing requirement, but they ended up casting their votes for a bill without one on AESs because that's the only way it could get passed. So it doesn't matter what their desire was. They agreed to the final product because that's the only way it could pass both houses. And as we did, we have another 35 minutes, as we did last committee hearing. If any other member wants to comment on this question, this certainly provides the opportunity. I can just tell you, committee members, we had nothing but positive response from folks watching on both sides of the issue of the fact that we actually discussed things. I've worked in about half a dozen legislatures around the country, and what we did last Tuesday in this committee is what happens every week in every other legislature I've ever worked in. For whatever reason, it has not happened routinely in Michigan, but I think it should. Representative, oh, and by the way, I know legislation is in the works to expressly reverse the decision of the Public Service Commission. And so this committee, we didn't expect to be here. I mean, we're back addressing substantively the biggest issue we fought over for 2 years last year. We thought it had been resolved, and yet here we are. Once again, we're about to start that process on the substance all over again after we thought a deal had been cut. But legislation is forthcoming, maybe coming as shortly as even potentially next Tuesday, because somebody noted it's not a difficult bill. It just simply, see, the Court of Appeals said if you took specific language out of a bill, you didn't have to replace it with language that says thou shalt not do that thing. That the court interpreted just your taking out of the bill was the same thing as thou shalt not. So you don't have to put the thou shalt not. But apparently with the Public Service Commission feeling free to interpret it differently, we may be compelled to put the thou shalt not, or at least attempt to do so, and we'll see whether or not that's received favorably by members of this committee, the House, the Senate, the Governor. Representative DeAnda.
Thank you, Mr. Chairman. The question I have for you is, was there a response to the letter from the two representatives that got sent to the Chief of Staff at the Governor's office along with Valerie Brader? Have we received anything, any correspondence from those two representatives on a response?
Not to my knowledge, and it's possible if we're still here in the next 35 minutes, Representative Verheulen was going to try to be here. We've got another 35 minutes, at least I told him, for the normal committee meeting time. So if he's here, maybe he could say so, but I'm not aware of any kind of response.
My second question, Mr. Chair, is the fact, is there any more discussion that was done on adding a few more people to the Public Service Commission? I know that our former colleague, Representative McBroom, had some ideas and some past legislation that he looked at for adding a couple more people on that Public Service Commission that were pretty much just ratepayers and not people of any other stature.
Representative DeAnda, my staff has researched how 18 other states handle Public Service Commission type bodies, or Public Utility Commissions they're called in some states. And we intend to come forward with multiple suggestions for reforms, including the possibility of increasing the number. And it would be my hope that that would be a bipartisan package. Would certainly welcome your support for it on that particular point of increasing the number to 5. The other would be as to the qualifications of members of the commission. The other would be how are they appointed. For example, in Ohio, a citizens panel comes up with a number of recommendations that goes to the governor, and he must select from one of them. And if he doesn't like one of them, it goes back to that citizens panel, so he's not compelled to appoint a particular selection. So we're looking at a broad-based reform of the Public Service Commission, and it's one of the issues on which I have some preliminary indications that the Senate might actually be interested in doing something else too. So that's coming, and we welcome your support and involvement on that if you would like to be a part of it.
I guess one more thing, if I can, Mr. Chairman. I guess the representative from the greater 108th brought it up, and I'm going to comment on it too. I mean, I think the committee should start thinking about this also. You know, in our 7 counties, the district I represent, on the very west end, I'm paying 7 cents a kilowatt, and in the rest of my interior, I'm paying 27. So I think that this is the point that we got to start looking at for, you know, not just our section 2 of that UP area, and finding out what we can do with our Canadian partner too in Ontario, and see what their rates are. And I wish I could have had a chance to ask the chairman about that, and what kind of structure and amounts do we have north of us. Thank you, Mr. Chairman.
Thank you, Representative DeAnda. The chair of the PSC did indicate that she would be available to come back, I think, the first Tuesday in October. If there are further questions members of the committee would like to ask her on this question or any other issue, so if you'd like to have her come back, just give us some indication. I don't have anybody else signed up to ask a question, make a comment. If there are no further comments, there's something, what is there, one more thing? Motion to excuse Representative Guerra. And so moved by Representative Elder, and without objection so ordered. Of course, we've excused Vice Chair Lisinski, and I think that's everybody. And with that, the House Energy Committee is adjourned.